and call the case right now. And I said we're going to start with case 2020-CA0019M. Each party will, and that is Bradley Knapp versus Tom Husa et al. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, let me know when you begin your argument. I'll be keeping track of the clock. I'll do my best to try to keep you apprised of how much time you have remaining as your argument proceeds. These arguments are being visually and audibly recorded and will be posted online. We have read your briefs and we are ready to proceed when you are. And in this case then, Mr. Owens, you go first.
Yes, thank you. I'd like to reserve 2 minutes for rebuttal, please.
Did you say 2?
2 minutes.
Okay.
Yes. Thank you. Your Honors, this appeal asks this court to decide whether civil litigants and their counsel in the state of Ohio can be sanctioned when they have minimal factual and legal support for their arguments under Revised Code Section Symbol 2323.51 after they lose on summary judgment, and also whether such sanctions can be assessed when the parties to be sanctioned did not have notice of the sanctions hearing and therefore were deprived of due process as supported by multiple uncontroverted affidavits. We also ask that this court decide in this case whether attorney fees awarded as sanctions are proper and are found to be necessary and reasonable when there's only argument from counsel, no corroborating evidence in order to calculate the lodestar under the Bittner case. But most fundamentally, the first issue we feel is that Husa was not a party in this action. Under Civil Rule 3A, an action is only commenced if you obtain service within 1 year. Service was not perfected within 1 year, as the trial court found in its July 2nd, 2019 journal entry. It ruled that no service was perfected, and Husa consistently argued this as an affirmative defense in the case. So without there being any commencement of the action as against Husa, they were never a party in the legal sense, and therefore they should have had no standing to seek sanctions against the sanctioned parties in this case. Second and third assignments of error, there's a two-step process in this district for awarding sanctions, as you know. First, it must be determined whether an action taken by the party to be sanctioned constitutes frivolous conduct. And that, of course, is a legal determination, which this court can review de novo. And then secondly, what amount, if any, of reasonable attorney fees necessitated by the frivolous conduct is to be awarded to the aggrieved party, and that would be under the abuse of discretion standard. In order to be frivolous, there has to be egregious conduct. It's judged on an objective standard. It must be said that no reasonable lawyer would have brought the action in light of existing law. It wasn't in the statute. 232351 was certainly not intended to punish mere misjudgment or tactical error, and a party need only minimal evidentiary support for the allegations or factual contentions in order to avoid a frivolous conduct finding. Here, we presented a plethora of deposition citations to the lower court establishing at least minimal evidentiary support for all of the claims. These are set forth in detail on pages 21 through 24 of the brief of appellant. Therefore, we believe that it cannot be said that no reasonable lawyer would have brought this action in light of the existing law. And if this court were to uphold the sanctions against the sanctioned parties in this case, it would signal to all Ohio attorneys that they need to fear the imposition of sanctions for doing nothing more than zealously representing the interests of their client. The trial court further erred in this case by finding that appellant was not a real party in interest. Appellant certainly was harmed by Husa's negligent and fraudulent conduct. As of September 20th, 2016, he received a certified letter from the boat purchaser, Mr. Anderson, who demanded his money back, threatened legal action against Mr. Knapp. He also survived motions to dismiss from both the Husa parties and Xanterra including on the same statute of limitations grounds that the trial court ultimately granted summary judgment to the Husa parties on. As you know, claims of fraudulent inducement, negligent misrepresentation, fraud, and conversion have 4-year statute of limitation. Based on the discovery of the fraud and the misrepresentation on September 20th, 2016, when the certified letter was received by Mr. Knapp, the claims were filed within the 4-year period, especially when you consider the discovery rule that applies for each of those cases. The trial court further erred in this case by finding the absence of any damages. Ohio courts have expressly recognized that attorney fees and punitive damages are available to a boat purchaser when the seller fails to disclose the extent of structural damage and the boat is resold, and that's what happened here. There was structural damage that was hidden by Mr. Husa when Mr. Knapp purchased the boat. Ultimately, when he resold it to Mr. Anderson, believing that all the structural issues had been fully remedied by Mr. Husa, he found out that that was not the case.
Knapp bought the boat for $12,500, I believe, and sold it for $13,000. So he actually made $500 on the deal.
Of course, he bought the boat, Your Honor, believing that it was worth substantially more than that. So there was a benefit of the bargain damages argument that we had as well.
Did Knapp do his own repairs on the boat?
No, he did not. The repairs were all done by Mr. Husa.
After he bought it, no repairs were done?
Before he bought it,
okay.
the repairs were done by Mr. Husa.
It was 1.5 years in between the time he purchased it, though, and sold it to Mr. Anderson.
There was, however, he only used the boat twice, he testified. Once he took it out on the water for a very short period of time, just to make sure that it was holding water at that time. He kept the boat stored and took it out 2 times for very short periods of time. The other issue, our fourth assignment of error that we want to emphasize today, is the lack of notice of the sanctions hearing. Both myself and Attorney Grubb, and we also had our office manager, Monique George, submit affidavits to the trial court, which established that none of us received any notice from the court of the sanctions hearing. Had we absolutely would have appeared and made argument against sanctions. Due process requires at a minimum notice and an opportunity to be heard, and we feel that we were not given that in this case. It's mentioned on the court docket that notice was mailed. There's simply a notation to that effect, and of course the mailbox rule creates a presumption of receipt, which is rebuttable. We feel that we rebutted that with our affidavits. And there was no proof presented that the notice actually was made it to the post office and was sent out to our office. So those uncontradicted affidavits, we believe, were enough.
Did you have a duty to check the docket as the court found?
There is a duty to keep apprised of the docket, although, Your Honor, we obviously are limited in how often we check every docket for all the cases that we have. And we do rely on the fact that we get notices from this court. We're supposed to get notices from the trial court, and we didn't in this case. So we do try to keep apprised of the docket as much as possible. We did not see this notation on this docket.
How do those affidavits play into that issue? The 3 affidavits that were filed?
Well, I mean, according to, and I think we cited several cases for that, in particular the Amir versus Warner case out of the 9th District, and also the Brill versus Ohio Department of Job and Family Services case, also out of the 9th, where affidavits of counsel stating that they did not receive notice was held to be sufficient to require a new hearing where they could be present and present argument.
So you're arguing that as officers of the court, maybe those affidavits should be given more weight than a layperson's affidavit?
Well, not more weight, but that those affidavits should overcome, the general duty to check dockets. and that the court still has an affirmative duty to send notice to all the litigants and counsel when there's a sanctions hearing.
Wasn't there evidence, though, in the clerk of court's records that there was photographs taken of the front of the envelopes that are sent out?
I don't know that that postage was clear from those envelopes, that it actually was sent out to the Medina post office. I apologize if I'm incorrect about that, but there certainly was no there was no evidence that the Medina post office sent it to our address that I'm aware of. There was also an argument made below that this court's remand order should have provided notice of the sanctions hearing. Well, that order, of course, does not provide notice of a particular sanctions hearing. It returned the matter to the trial court for a 60-day period where the trial court could rule on all pending motions. And that order also provided that period could be extended if necessary based on extraordinary circumstances. And we believe that failure of notice should be extraordinary circumstances.
Can I quickly go back to the frivolous conduct issue? Did the court make any findings as to what conduct was egregious, unjust, overzealous? Yeah, my question was whether or not the court made any findings as to egregious conduct over frivolous conduct, egregious, overzealous, unjust, and if not, should it have? You're muted.
There we go.
There you go.
Sorry about that. Yes, the trial court seemed to base its finding on the fact that it believed that there were no damages. So the court felt it was frivolous for the case to be pursued in its opinion without damages, and also that all of the claims were outside the statute of limitations. And of course, we briefed both of those issues. The damages, our client was under threat of litigation by a third party, which would have been for substantially more, obviously, than what he received for the boat, and the condition that the boat was represented to be in after it was surveyed by the buyer, by Mr. Anderson. And of course, statute of limitations, the court did not take into account the discovery rule on those causes of action with 4 years with discovery rules such as fraud and misrepresentation, and the fact that our client didn't receive that certified letter until September 20th of 2016. So we believe that the causes of action were viable, and we survived 2 motions to dismiss, which is another argument we made to the trial court. I mean, if this was so egregious, well, why did the case go beyond the motion to dismiss? We litigated this case for several years. So we believe that the trial court erred in making such a determination. Final issue I wanted to bring up was for our 7th assignment of error, that the number of hours that was presented to support the sanctions award in favor of the Husa parties. Most of that time was for issues that they lost, that we actually prevailed on. It was for their lost summary judgment motion, and it was for a failed motion to compel that they filed, and other issues that were not related to any sort of sanctionable conduct. So we believe that even the $3,180 that was awarded was not a proper amount. It wasn't a reasonable amount, and of course did not reflect necessary and reasonable attorney fees. And with that, I would save the rest of my time for rebuttal.
All right. Mr. Tabak?
Will be brief. When this lawsuit was filed in 2013, their client had sold the boat for a profit. They knew there were no damages. Thus, that issue would not appear in a motion to dismiss, which is based solely on the law. A frivolous lawsuit is one where there are no damages and would not be brought by a reasonable lawyer. In this case, Mr. Anderson, who purchased the boat, could not find a lawyer, reasonable or otherwise, to bring a lawsuit. That's my position.
You're finished?
I'm done.
All right.
I just have one question. So, Mr. Tavik, your opinion then is that because Mr. Anderson couldn't find a lawyer to bring a suit to sue Mr. Knapp?
Knapp, yes.
Okay. So there is no suit pending, is what you're saying.
I'm sorry? I didn't
So
hear
there's
that.
no suit pending, is what you're saying.
No, there never was one filed.
Thank you.
And you're welcome.
In rebuttal, I would say that Mr. Knapp, of course, didn't know whether Mr. Anderson would sue him or not. There was a threat of suit pending. Unbeknownst to him, there was still significant structural damage, structural issues with the boat, which came to light through the purchaser Anderson's survey that he had done. Once our client found out that the boat was in such a structural condition and under threat of suit by the purchaser, that is the point that he determined that he had claims to assert against the Husa parties, and that's why the lawsuit was filed. So there was no frivolous conduct. As to the statute of limitations issues, the court could have decided that on motions to dismiss and did not. It was clear what was being asserted. The factual allegations were clear in our complaint. The discovery rule had been argued, and the court allowed the case to proceed.
All right. Gentlemen, thank you both for your arguments on this case. If you're ready, we will proceed to the next one.